So Disney's about the scummiest company on the face of the earth, and no, I'm not just talking about the type of quote-unquote entertainment that they put out there. In a legal sense, everybody knows that Disney hires the absolute biggest sharks available. They have one of the most accomplished legal teams on the face of the earth. It's a company that if you go against, you better come correct. That's why people are paying attention to the Elon Musk Gina Carano lawsuit, seeing them collect some W's along the way. Last year with Ron DeSantis firmly beating Disney in the Reedy Creek scenario, thinking that, oh man, are there potentially some cracks in the dam? Is Disney legal? Not quite the juggernaut that they used to be? Will they perhaps take a step back? Make fewer rash political decisions, try to come across as maybe a little bit more humanistic, and then you get stories like this, and it's like, nah man, this is still going to be Disney until they're dead and gone. Borders on the absurd. Dead woman's estate rejects Disney's claim that widower's Disney Plus membership means wrongful death lawsuit must be arbitrated. I beg your pardon? What is going on here? Now, it's a little bit more complex than that, but it basically all boils down to a guy's wife died. He was trying to sue a Disney restaurant for a wrongful death claim, justifiably so, right? But Disney shot back with, hey, you signed up for a free Disney Plus subscription 3 years ago, so yeah, I am agreeing to the terms of service. Whenever you sue us, we have to default to arbitration. I kid you not. Does a Disney Plus membership keep you and your loved ones out of the court system in the event of an alleged Disney-related death? I can't believe that is a statement. That's what the mouse-themed entertainment company would have a court believe, and what a dead woman's family is fighting against. Dr. Kanokporn Tangsuan, right, died in October of 2023, allegedly because her meal at a Disney World restaurant in Florida contained nuts and dairy, well-known allergens in which she was deathly allergic. And I don't know if they elucidate that point in this article, but the reason that Dr. Tangsuan, Dr. T. The reason Dr. T decided to take his wife to said restaurant is because they advertise that we take our allergy concerns very seriously, which is why, a wrongful death suit seems to be, the right course of action, obviously. Rather than contest the facts or litigate the merits of those allegations, however, Disney wants the case to be decided by a preferred arbitration organization. The result is mandated in this case, the company says, because Tangsuan's widower signed up for the Disney streaming service, and in doing so signed a contract which agreed that any and all disputes with the company would be decided through the use of a mandatory binding third-party arbitration. Unbelievable, right? So it's not even the lady who died who signed up to the suit, okay? They're trying to take signing up for a streaming service that has nothing to do with the restaurant, other than them being under the same parent company, right? Trying to apply that terms of service that everybody just scrolls through in order to check the box at the bottom of, somewhere hidden in the fine print. They're trying to hold that up so that they aren't held liable for killing one of your loved ones by not adhering to their own business practices. That's insane. And yeah, also using that same terms of service that she likely didn't even sign up for. This is somebody else signing up for this. Therefore, they're not entitled to proper compensation of somebody else's death. It's okay. All right. Attorneys for the deceased woman's estate are in turn employing a judge to reject what they call an incredible argument. It is definitely incredible. Lacks credibility 1000%. They say Disney's position would mean anyone who signs up for a Disney Plus free trial will have forever waived the right to a jury trial enjoyed by them and any future estate to which they are associated. And Disney was probably in the courtroom going, yeah, exactly. That's why we worded it that way. Scumbags. As can be seen in the prior sentence, this argument borders on the surreal, the plaintiffs argued in the 123-page filing on August the 2nd. As Law and Crime previously reported, Jeffrey Piccolo filed a wrongful death lawsuit in Orange County Circuit Court in February. Piccolo, his mother, and Tangsuan ate at a Raglan Road Irish Pub and restaurant in Disney Springs in the evening of October 5th, 2023. The trio only chose the restaurant in question because both Disney and the staff made it repeatedly and abundantly clear that Raglan Road had proper safeguards to protect patrons from food allergies. There you go. That's not me just BSing BSing over the top of this to make Disney look even worse. It's right there in black and white, as Tangsuan was highly allergic to dairy and nuts, the lawsuit alleges. Raglan Road advertises and represents to the public that food allergies and or the accommodation of persons with food allergies is of top priority, and the patrons' guests must consult with a chef or special diet-trained cast members before placing an order, and at all times material plaintiff relied upon the representation in selecting Disney Springs Raglan Road for dinner. The lawsuit filed in the Great Irish Pub, Florida, and Disneyworld Parks and Resorts, U.S. reads, but Tangsuan died from an allergic reaction later that same night, and that does not appear to be in dispute. According to the copy of the autopsy report obtained by Law and Crime, the medical examiner performed a series of tests and reviewed Tangsuan's medical records before determining that she died as a result of anaphylaxis. The manner of death was determined to be an accident. The autopsy report shows that the doctor had very high levels of nut and dairy allergies in her system when she died. Attorneys for Disney took stock of the family's lawsuit as involving an allergic reaction that the decedent allegedly experienced after dining at a restaurant called Raglan Road Irish Pub and Restaurant located in Disney Springs. In a motion to compel arbitration filed May 31st, company's court filings then tersely rubbishes the lawsuit as alleging the agency's relationship between landlord and tenant, and argued the only facts supporting this theories are representations about Raglan Road's allergy-free foods. Right, we just say that they're allergy-free. You can't actually, hold us to that. Come on. On the Walt Disney World website, right, and noting that Piccolo alleges that he relied on the website in choosing to dine at Raglan Road. They tried to hold us to our word, but you can't do that because reasons. And did you remember you signed up for Disney Plus? But the company's filing goes on. It eschews any further reference to the merits of the case, as Piccolo alleges in his complaint. Much more important to the point of controlling the issue in the case, Disney says that is that Piccolo ignores that he previously created a Disney account and agrees to arbitrate all disputes against Disney, which is hilarious. Okay, so they want to put themselves, they want to separate because it's just a landlord tenant affiliation that we have with Raglan Road, but then they want to go ahead and assert their full Disney-ness over the top of this by saying that, okay, cool, well, you signed up for Disney Plus. They really want to have it both ways on this one. The company's filing sketches out the fact that they believe are relevant. In November of 2019, just about 3 years before this took place. Just about 4 years before this took place. Holy, I was underselling this. Piccolo initially created a Disney account through the Disney Plus website. Piccolo completed the registration web form by providing personal information, including an email address, and created a password. Yeah, we've all signed up for online accounts before. Before registering the account, Piccolo had to select and agree and continue. Yeah, immediately above is disclosed, notifying Piccolo that by clicking agree and continue, you agree to our subscriber agreement. The term subscriber agreement was underlined in blue font and provided a hyperlink directly to the document, right? Yeah, see, we did our due diligence besides, maintaining an ethical menu. After agreeing to the terms and conditions, Piccolo purchased park tickets and registered the decedent as his guest. That's his wife. Piccolo could not have completed the purchase without agreeing to the Disney terms. So we trap you in this unethical relationship that, if anything happens to you at this point in time, we aren't actually held liable anymore. You have to go to arbitration. Unbelievable. The company's May 31st filing also references some legalese from the subscriber agreement they claim is operative. Piccolo agreed to the delegate arbitrability issues to the arbitrator, blah, blah, blah. Piccolo's attorney also says that Disney is actually wrong about the agreement their client signed. Oh, really? In a footnote, the lawsuit says that the billion-dollar multinational company incorrectly relied on testimony that the Disney Plus subscriber agreement between Disney DTC and its affiliates, erroneously quoting language from Disney's terms of use rather than the Disney Plus subscriber agreement. Oh, okay. So they're trying to screw you with one terms of service that doesn't directly link them to the lackadaisical standards of a restaurant. They're trying to use another terms of service as a go-between. Interesting. From the Piccolo response, second, even if WDPR had not waived its rights, it is attempting to enforce an agreement that was never signed against a party who has never signed. Yeah, exactly. That's kind of the big hurdle to get over here. Specifically, the plaintiff in this wrongful death case is Jeffrey Piccolo as personal representation of his estate of Kanokporn Tangsuan. I'll never get that right. Not Jeffrey Piccolo individually, stating that the only decedent's personal representatives may bring a wrongful death action on behalf of the survivors. And in this motion, WDPR nonetheless improperly attempts to negate this distinction by making the preposterous argument that when Jeffrey Piccolo individually allegedly signed himself up for a free trial on Disney Plus back in 2019 or bought Epcot tickets in 2023, he somehow bound the non-existent estate of Tangsuan, his wife, who was alive both times, to the arbitration agreement buried within certain terms of conditions. Yes, a court hearing on this matter is stated for October 2nd before Orange Circuit Court Judge A. James Craner. But we do in fact have a development, okay, one that Disney, after receiving substantial backlash, because this is a story that has been circulating for, I know, the better part of a week, right? Like it was reported first August 13th, okay? A little bit better than a week that, I'm bringing this to you. But yeah, this is all, of course, predicated on this development. Disney had decided, right, out of the goodness, out of the benevolence of their heart, to waive its right to arbitration and allow the matter to proceed in court for the recent wrongful death lawsuit where they attempted to use the widowers' Disney Plus subscription to arbitrate. Get this one. Strap in, folks. At Disney, we strive to put humanity above all other considerations. Unbelievable. When they were trying to jump through all of those different hoops to try to tie this guy whose wife died because of the neglect of a Disney restaurant. Now they're trying to run this back and say that we put humanity above all else. I hope this guy gets millions and millions of dollars off of this. Disney, you're such a scummy company. But then at the same time, with this revelation, I also never want you to change, because it's oh so funny to point out just how disgusting you guys really are. So with all that said, thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.